Hi, I'm Bill Perkins. If you love the Lord, love your Bible, and love to learn, you're going to love this presentation. Jenna Ellis was homeschooled through high school before going to law school. Then she became a Colorado prosecuting attorney, and then a contract litigation attorney for the State Department. I met Jenna in Denver. After talking to her for just a few minutes, I asked if she could put together a conference presentation showing how closely our Constitution is tied to the Bible. She accepted the challenge, and as a result, it's the video you're about to see. After making this presentation at the Stealing the Mind conference in Denver, she worked with Focus on the Family and is now a Fox News business analyst. So sit back and enjoy the U.S. Constitution and the Bible by Jenna Ellis.
Well, good afternoon. I'm so excited to be with all of you here at Stealing. And as John Lennox, who's a famous apologist, loves to say, to every speaker there belongs a story. And Bill shared with you a little bit about my story. And the most important thing that you do need to know about me is that along with being an attorney and loving the law, I am also a student of the law, but the law that originates in the Bible. So I am really excited to present to you the U.S. Constitution and the Bible. The first thing that we're going to talk about, our premise, is going to be a case for biblical interpretation of constitutional law. So, doing that, we're going to give you the tools to understand the U.S. Constitution in its lawful and legal context, and we're going to define what those terms mean as we go along. I'm going to give you the answers of why any interpretation of the U.S. Constitution must be consistent with biblical truth. And then finally, I'm going to show you how Christians must change the basis of our appeal in constitutional law. So this is the outline of how we're going to go through this presentation. First, we're going to talk about the Founding Fathers. As lawyers, I'm sure any of you who've been around the Christian community know that there's a lot of speakers who give wonderful presentations that give a compelling case for the founders as Christians rather than deists. That's very important. But today, I want to talk about the founders as lawyers. Many people don't know that the most influential and prominent founders actually were lawyers, and we're going to talk about that. We're going to talk about the law. What is the law? And some key fundamental legal concepts that would have meant something to our founding fathers. And then finally, we're going to look at the founding documents themselves, not just the Constitution, but the roots in the Declaration of Independence, the Federalist Papers, as legal writings and what that means. So this is going to move really fast, and I'm really excited, so jump on board with me, and here we go. The founders, all of the founders and the most prominent and influential, with the exception of George Washington, were lawyers. Of the 56 signers of the Declaration of Independence, 25 were lawyers. Of the 55 framers of the Constitution, 32 were lawyers. Particular words and phrases in the law, as I'm sure any of you have read any type of contract or any type of leasing agreement, that have a lot of legalese in there, but that means something to lawyers. So understanding that the founders actually were themselves lawyers, the terms and phrases that they put into our founding document meant something to them. And beyond that, their education in the law also meant that they had a very clear understanding of the legal terms and concepts that were the basis of our separation from England and are the roots in the Declaration that then give the rationale for the Constitution itself. So we're going to talk about 6 particular founders. The first 3, the first one being Thomas Jefferson. He was an attorney admitted to the Virginia bar, was a principal author of the Declaration and a drafter of the Constitution. The second, John Adams, he went to Harvard, was admitted to the Massachusetts bar, and he assisted Jefferson drafting the Declaration. Benjamin Franklin, he had an honorary doctor of law, so he's educated in the law, although he never practiced. We know him better as an inventor, but he was very well-versed and educated in law. He was on the committee drafting the Declaration and also signed the U.S. Constitution. Of those 3, there were also 2 other lawyers, Sherman and Livingston, who were founding fathers. These 5 lawyers comprised the Declaration Committee, with the principal drafters, again, being Jefferson and Adams. So once we get into looking at the text of the Declaration, remember that these 5 drafters, it meant something to them, all of these words and phrases. And then the next three, starting with Alexander Hamilton, these next three were the authors of the Federalist Papers, which, as we will see, show the rationale for the U.S. Constitution. The first, Alexander Hamilton, he was admitted to the Virginia bar and was a principal drafter of the U.S. Constitution, and again, a principal author of the Federalist Papers. John Jay, he was admitted to the New York bar. He was a principal author of the Federalist Papers and was the first Supreme Court justice. You might have heard of the John Jay Court. And then finally, James Madison. He went to Princeton University, and like Franklin, he never studied or never practiced law, but rather he studied law for the exact purpose of public policy. He knew the importance of understanding the law and the study of it in order to understand these legal concepts. He was a principal author of the Federalist Papers and also drafter of the Constitution. So now hopefully I've given you an awareness and a basis of more to our founding fathers than just being statesmen and just being Christians. Though those are very important concepts, and certainly we should advocate for their belief in God and in the one true God, understanding that they were lawyers now gives an even more important meaning to the terms in the papers. So let's talk about the legal concepts that these founders would have known and would have appreciated as they were trying to articulate the basis of our foundation in law. The first concept that I want you to be aware of is called legitimacy in law. Legitimacy is hugely critical to anything that we do in law. Legitimacy means lawfulness and inherent authority by virtue of being authorized or in accordance with truth. It's conforming to a valid, rightful, and appropriate authority. So there's a difference between lawful and legal. Lawful is in accordance with morality. It's God's law. Legal is simply in accordance with civil laws. That's the distinction. So what is the law itself? When we talk about this, we call this the body of jurisprudence. It's the study and theory of the law. And the founders were aware of this. They were also aware of two theories of law's origins, and these are critically important to the discussion of the U.S. Constitution today. They are natural or divine law, which that's really saying the same thing, whether you call it natural or divine law, and legal positivism, which is also known as the social contract theory. Natural or divine law. I personally like using the term divine law because when we enter a secular forum and we say natural law, that can also to them mean science or something that's scientifically based, not necessarily acknowledging God as the creator and the divine legislator. So when we talk about natural or divine law, I like to use the term divine law to make sure that we acknowledge that we are in accordance with biblical truth. This is the theory that law is fixed, ordained by God, and discovered by man. I put this in quotations because that word discovery is the same thing as a scientific principle. We didn't think that we all just got together and decided that the law of gravity might be a good thing, and we can choose to ratify that or ignore it if we want to. We discovered that principle and then built other things in science upon it. In the same way, divine law tells us that the laws of morality in God are already fixed. They're exactly like scientific principles as applied to morality that are just discovered by man. And we cannot do anything in our law apart from God and his law of morality. Law has a rational, objective limit to the power of legislative rules. So it supersedes and it is over any civil law that we might impose. God gives the authority and enforcement to the law, and there is inherent lawfulness and morality. So again, we're talking about lawfulness, not just the legal civil law. So let's compare and contrast that with the social contract theory. This is the theory that law is fluid, ordained by man, and can be changed by man at whim. Law has no inherent limits, but that which the legislature sets. Collective society, rather than God, gives the authority and the enforcement to the law. So then, there's no inherent lawfulness or unlawfulness. Everything is purely legal. And you can start seeing how this is what our courts and what everyone talking about constitutional law is grasping on today. They are talking about the social contract theory. So I have a great little chart. I'm a big fan of charts. This is divine law versus social contract. We're going to talk about the origin. Divine law, the origin is God himself. In social contract, the origin is man. The rationale or the reason behind the law. In divine law, it is a fixed and objective standard that never changes and is eternal. Under social contract, it's fluid, it's subjective. The authority under divine law is God's sovereignty. Social contract is man's agreement. We can agree to something, we can agree to something else later. Enforcement, moral law. Like any other scientific principle, it is fixed and it doesn't change. God's supremacy is the enforcement. Social contract theory says that the enforcement is simply codified law, or the statutes, or the things that we understand are the rules of society. And the enforcement is the power of man's force through the government. So then, the interpretation of the laws under divine law, they must be consistent with biblical truth. Why? Because we have a fixed and objective standard. We have moral law under God's supremacy. Under the social contract theory, we have the interpretation of laws are changing to the whims of a dominant society. And it's just by virtue of man's agreement, and it's enforced by the power of man. So now talking about U.S. or divine, U.S. law. Is it divine law or social contract? We'll get into the fact that today everyone is arguing for social contract theory, but really it is rooted in our founding documents that it is in divine law, and that's what we're making the case for today. So the founding legal documents, the Declaration of Independence, it gives us in its very text that we will look at authority in divine law and legitimacy, meaning in accordance to lawfulness, as we discussed earlier. It's legitimacy for sovereignty and becoming a sovereign nation and separate from England. We'll look at the Federalist Papers, which give us the rationale and the reason for a new government, and that the U.S. Constitution is just the supreme laws that were delegated to government, not the other way around, and that the supreme laws of the U.S. Constitution are under the authority of a lawful morality, and it's God's law. So this is another chart, the founding documents hierarchy. This is the pyramid, and this is what we have to go back and establish. There is a foundation in divine law. This is the authority. And then the Declaration of Independence, premised upon divine law, gives us the legitimacy. So let's look at the founding of America in the Declaration of Independence, divine law or social contract. Divine law tells us that a legitimate authority for a new government through the rights that transcend king or man. A social contract theory tells us that we have an illegitimate authority for rebellion against the government. That just whatever the force of man is, if you go opposed to that, then that's just simply rebelling against the government. That's treason. Our founding fathers understood that they were appealing to a higher law, to divine law, for a legitimate authority for a new government and for a revolution to secure our rights that transcend king or man. The Declaration of Independence, it gives us our legitimacy and authority to become a sovereign nation. What does it tell us? That our rights are unalienable and come from God himself. Our rights pre-exist the Constitution. Our Constitution is not what conveyed our rights, and we'll see that. The only purpose of government is to protect our God-given rights. And so therefore, when government usurps our God-given rights, it is not only the right of the people who are governed, but also the duty of God's people to abolish that government. And that is what our founders understood. Amen. So the Declaration legitimized the independence of the United States to separate from England, asserting our divine rights, including the legal rights, but our divine rights from God himself and the right and duty of separation and revolution. Again, the government is only legitimate and only has authority when it operates to protect our God-given rights in accordance with God's divine law. So let's look at the very text of the Declaration itself. And this is what we don't see anyone in the court system today appealing to. Go back to the Declaration. when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with one another, and to assume among the powers of the earth separate and equal station which the laws of nature and of nature's God entitle them. You see, our founders who were lawyers, they knew they were appealing to divine law and the divine laws of nature and nature's God who entitles us. It is not conveyed by the government. And this is in our very text of the Declaration of Independence. A decent respect to the opinion of mankind requires that they should declare the causes which impel them to separation. This was their entire thesis, and saying, we no longer can go with the civil authority because our God-given unalienable rights are being violated. And so we have legitimate authority to separate from England because we appeal to a higher standard. We hold these truths to be self-evident, that all men are created equal. Truth, they were talking about absolute truth. Self-evident, meaning we don't need the legislature, we don't need the judiciary to declare it, we don't need to codify it. They are self-evident, they are given from God. That all men are created equal. They're endowed by their Creator with certain unalienable rights. That among these are life, liberty, and the pursuit of happiness. So let's talk about these unalienable rights. Divine unalienable rights, as I mentioned before, and legal rights are two different types. Legal rights are those bestowed onto a person by a given legal system or government, like the ability to have a driver's license. We're licensed by the state to go on the roads, we have to pass certain tests. That's a privilege. But as anyone who's ever had a lot of traffic tickets would tell you, some of whom I've prosecuted before, they would tell you that that's a license that can be taken away because that is a privilege granted by society. It's not an absolute right. As opposed to divine rights, those are not contingent upon the laws, customs, or belief of any particular culture or government, and are therefore universal and unalienable. No government can take away the rights that God has given you and me. No one. And the Declaration says so itself. And that to secure these unalienable rights, governments are instituted among men, deriving their just powers from consent of the governed. So this is the founder's statement that's talking about the purpose of the government, that to secure these unalienable rights, governments are instituted. Not to grant those rights, not to get together and agree upon what rights we think should be given to you or me, but that our only purpose in government is to secure the God-given rights that God himself gave us through divine law. And they go on to say that whenever any form of government becomes destructive of these ends, it is the right of the people to abolish it. Notice right is capitalized. Whenever any form of government, what does that sound like today? Our government is becoming destructive of these ends, and it is the right of the people to abolish it. They were talking about England. So the Declaration then lays out all of the charges against the King of England and all of the reasons which impel them to separation, and then says, we, therefore, the representatives of the United States of America in General Congress assembled, appealing to the supreme judge of the world. Who is it talking about? God. We are appealing to the supreme judge of the world for the rectitude of our intentions. Rectitude meaning morally correct behavior or thinking, and righteousness. We're talking about lawfulness. And for support of this declaration, with firm reliance on the protection of divine providence. Who are we talking about? God himself. We mutually pledge our lives, our fortunes, and our sacred honor. This is what our country was founded upon, ladies and gentlemen, and this is what we have to go back to. The Declaration, yeah, it's exciting. It is exciting. So we see the Declaration is a direct appeal to divine law. This is not the social contract theory. So to recap, it talks about the laws of nature and of nature's God. That is divine law. The origin of our government was God himself. They had a legitimate reason to separate from England. The rationale is a fixed objective standard. Our unalienable rights are fixed. They are objective and they're given from God himself from the direct text. The authority is God's sovereignty. So the enforcement then is moral law and God's supremacy, and it is our duty as consent of the governed. We are the ones who are being governed. And so if we continue to consent to the changing of our laws that are not premised on divine law, we are consenting, ladies and gentlemen, and we are giving our courts, especially, and also our legislature, we are giving them our consent when we sit back and do nothing, and when we do not direct our courts and our judges back to divine law and the true roots of what America was founded upon. So the interpretation of civil law must be consistent with biblical truth. It must be. So let's go back to this pyramid, the founding documents hierarchy. Divine law gives us our authority for our nation. The Declaration of Independence gives us our legitimacy. It gives us the lawfulness. And now we'll talk about the Federalist Papers. These are often so overlooked. They're not even taught in most schools anymore, and few people even read them. This gives us the rationale for the U.S. Constitution. And based upon the Declaration of Independence, what we then wanted our civil government to do that was different from England, and how our civil government and its only purpose would be to protect the unalienable rights that we declared through our independence. So looking at the Federalist Papers, what were they? They're 85 articles and essays that were written by the three founding fathers that we talked about earlier: Alexander Hamilton, James Madison, John Jay. Again, all lawyers, all attorneys. They promoted the ratification of the U.S. Constitution and shows the rationale of the supreme civil law. Number 84 by Hamilton is key, and I want to point out a few things in number 84. Hamilton argued in number 84 that it was unnecessary and dangerous to add a Bill of Rights to the U.S. Constitution. Why? He was concerned that future government leadership could then say that the rights were given or conveyed by government and therefore could be taken away rather than being unalienable. And so the text of 84, bills of rights, in the sense and the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous, affording a colorable pretext, and we'll talk about what that means, affording a colorable pretext to claim more government restrictions on our God-given rights. That's happening today, ladies and gentlemen, and Hamilton, at the foundation of this nation, was concerned about that very thing, knowing that we were not a social contract theory government, but we are premised and rooted in divine law. So colorable pretext, what does he mean by that? And again, these are legal terms that have specific meaning to lawyers. A pretext is a motive or purpose alleged in order to hide the real purpose or reason for doing something. Again, if you've ever gotten pulled over for a ticket, I have. A lot of times if it's late at night and you have a headlight out, a cop will pull you over under the pretext of seeing what you're doing. But really, you know that the real reason for that is they're probably saying, are you drinking and driving? Do you have a license? Do you have something like that? They're not quite as concerned about your missing headlight. But that's a pretext for pulling you over. Colorable means a plausible legal claim, a claim that's strong enough to have a reasonable chance of being valid if the legal basis is generally correct. So in law, when we talk about a colorable claim, that means that if the premise of what we are claiming actually is true, there is a valid legal basis. So a colorable pretext then means that there is a claim that's strong enough to have a pretext. So it's a plausible claim. So going back to, actually let's go back here. So Hamilton says it would be dangerous to have a Bill of Rights in the Constitution. Why? Affording a colorable pretext or a plausible reason to claim more government restrictions on our God-given rights. And we're going to talk, that's exactly what the courts are doing. They're going and saying that this Bill of Rights, we are going to put even more and more restrictions on our freedom of speech, our right to keep and bear arms, our freedom of religion, all of those things. That's exactly what's happening. So Hamilton goes on, "For why declare that things shall not be done in which there's no power to do?" Why should we put a Bill of Rights in there when the government can't restrict our unalienable rights anyway? That makes sense. Why should it be said that the liberty of the press shall not be restrained when no power is given by which restriction should be imposed? He's acknowledging there is no power or authority in our system of government to restrict our unalienable rights, friends. And he goes on finally to say, "I will not contend that such a provision," meaning the Bill of Rights, "would confer or grant a regulating power to the government, but it is evident that it would furnish to men disposed to usurp a plausible pretense or that colorable pretext for claiming that power." And that's right there in the Federalist Papers. So going back to our founding documents hierarchy, our authority is in divine law. The Declaration of Independence shows our legitimacy and authority to separate from England, and that we were founded upon divine law. The Federalist Papers give us our rationale not to divine law itself, only God gives us that, but rather the rationale for then the supreme law of the land. That's the civil law. That is not what God conferred upon us. That's all the way down at the bottom in divine law. The Constitution is the supreme law, but it is built upon all of these very, very important foundations. So let's talk about the U.S. Constitution. As we said, it is the supreme civil law of the United States. It's important. It is the civil law. And it is only the civil law. It's the nuts and bolts. It was framed by 55 delegates to the Constitutional Convention, and it is a legal document. 32 signers were lawyers. There was particular meaning, and it meant something. Its sole purpose, premised in the Declaration of Independence, is to preserve the unalienable rights under the legitimacy of the Declaration and God's vested authority in government to structure itself only and solely in accordance with divine law. We do not have any authority whatsoever, even in our U.S. Constitution, to do anything, interpret anything, make any law that is not in accordance with divine law. We have to understand that. So when lawyers in the courts talk about U.S. constitutional law, what are we really talking about? Constitutional law is the body of law that interprets and forms judicial case law and precedent from the written text of the Constitution. What does that mean? We have this document, we have the supreme law of the land, and then when any case comes before, or any controversy, whether that's a criminal law case, a civil law case, whatever it is, that then will appeal to the civil law, and all of the judicial case law precedent, meaning the opinions by judges, the decisions they render, that forms the body of law that lawyers refer to as constitutional law. But we have to remember the legitimacy of constitutional law, the authority that it has, is from the Declaration premised on the authority that comes from God and divine law, not judges. Judges are not who give the Constitution breath and authority. It comes from the Declaration, which is premised upon God and divine law. That is the only authority it has, not judges. The text, absolutely, amen. And the text of the Constitution and civil law cannot be interpreted in a vacuum, apart from the rationale and the authority of the Declaration and foundation in divine law. It's the same thing as when certain churches or pastors will take one scripture verse and they'll take it outside of the entire context of the Bible and try to build a doctrine and biblical case law, if you will, that's based on just one particular verse. You have to take it in its entire context and in Scripture, and a lot of the speakers were great at talking about that earlier. And so the text of the Constitution is the same. When we try to separate the nuts and bolts away from the rationale, the legitimacy, the authority, We can't do that. It's then interpreted in a vacuum, and with the same problem that we have in building an entire doctrine around one verse that can be taken completely out of context, that is the same thing that our courts are doing today and what they've been doing for the past 100 years, that they are taking one text of the Constitution or one line, taking it way out of context, not even referring back to the Declaration of Independence, because they want to have a different outcome. They don't want to go by divine law and the inherent authority of God's law. So then we get our theories of constitutional interpretation. Judicial activism. Andy Woods talked about this earlier. That's what's happening today. It's rulings on constitutional law based upon political considerations, fluid interpretation, subjective meaning, the social contract theory, as opposed to what's called judicial restraint. These are rulings on constitutional law based on limited judicial power, limits on government, fixed objective interpretation, and legislative intent on divine law. And these are the two theories of constitutional interpretation which are at play today. And we've heard a lot about judicial activism, and the reason that it's becoming so prevalent is that everyone in the courts are talking about judicial activism, but they're not talking about what it's premised upon, and that's the social contract theory, that if we believe that our society just came together and formed an agreement, and that we can modify that agreement anytime or any place or with any reason we want to, then activism based on a fluid interpretation and subjective meaning, the evolution of society, we've all heard that term before, then that's why it makes sense to them, because they are trying to reframe the issue and reframe what our founding fathers genuinely framed and legitimately framed over 200 years ago. And it is scary, and we cannot allow it. So the founding documents, I love this pyramid. So again, the divine law, that is the foundation, the Declaration, the Federalist Papers, and finally the US Constitution. So what the courts are trying to do today is to draw a line right through the pyramid and literally just give you the tip of the iceberg as far as the rationale. They're wanting to take this entirely out of context and separate it from the true roots of American history, American foundation, and the inerrant, sufficient word of God and divine law. This is what the judicial activist hierarchy looks like. Social contract theory, which nobody really talks about, and then the US Constitution built upon social contract theory. But there is no legitimate authority in social contract theory. It is just man coming together. So then, when the US Constitution is founded upon the social contract theory, what do we have? Civil law that is divorced from morality. What the courts are doing today is taking the text of the US Constitution at the nuts and bolts of it, and they are trying to separate that element of morality out. And they are trying to divorce it from morality and say there is no legitimate morality, there is no basis, the separation of church and state, we have just our plain textual laws that are fluid and can be interpreted any way that we want. And that's how they're getting away with it. So interpreting the US Constitution, the authority for the government is in the Declaration and it's under divine law. And the Constitution itself even acknowledges that. So let's look at the text of the Constitution. We, the people of the United States, in order to form a more perfect union. And we all get so patriotic when we read this. I love it. We, the people of the United States, in order to form a more perfect union. What were they forming? Our system of government. And we, the people, it's us. It is the consent of the governed. So we consenting to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, all of the things that a civil government is vested by God to do. Why? And to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. It is setting out in the very first preamble to the Constitution that we, the people, are consenting to be governed by the Declaration's legitimacy premised in God's authority for divine law to establish our union for the express and sole purpose of securing the blessings of liberty and the blessings of God. And that is the only reason that we ordain and establish the Constitution for the United States. So interpreting the Constitution, these are part of the Bill of Unalienable Rights that we did ratify, and our founding fathers did add, and we've now amended. And these are some of the rights now that are being chipped away at by our social contract theory of our government that's illegitimate. The freedom of speech, the freedom of religion, the right to bear arms, protections as a criminal defendant, all of these that are in the first 10 amendments are known as the Bill of Rights. So we see we cannot allow the courts and the talking heads today and everyone who is talking about constitutional law, cut it off right here. We have to show the full understanding and awareness of the founding documents hierarchy. We cannot just go off of the tip of the iceberg and separate the Constitution as the supreme law from the rationale, the legitimacy, and the authority. So consider when you see this pyramid and all of our foundations in the Bible and divine law and the Declaration, consider how the foundation, if we understand that pyramid, really changes the outcome of these critical issues. If we had to go by what our country was really founded upon and our judges understood that that was the only way that they could rule was in direct support and under the direct authority of divine law, think about our critical issues. Abortion, how would things change? Marriage and divorce. We talk a lot in the Christian community about marriage and about the sanctity of marriage and the definition of marriage. But look at divorce, what's even become acceptable in the church. In Colorado, where I primarily practice, our standard for divorce is what's called irretrievable breakdown. That's a fancy legal way for my client to be able to come in and say, "Judge, I'm done, I'm out." That's all that needs to be said for a court to say, "Okay, then you can have a divorce." That the standard of irretrievable breakdown is not at all consistent with divine law. Privacy, education, God in society, and finally the limits of government and the composition of government itself. All of these things would change. So let's look at some of the case law that started changing the conversation and how we got away from divine law and how the courts very, very shrewdly started premising their decisions upon social contract theory and manipulating the conversation so that we would start appealing to the social contract theory, and that would become our precedent. Starting in 1947, Everson versus the Board of Education. This is a quote from that decision. In the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. They used Jefferson's words against him. As anyone knows with the foundation of history, if you're educated in history, that was not anywhere in our founding documents. It was not anywhere in the Declaration, but rather a private letter that Jefferson sent to the Danbury Church. And he was actually reminding the pastor of something that the pastor had told Jefferson years previously about how the state didn't have authority to usurp the unalienable rights given to the church. And that was the context of that conversation. But just like pastors take out scriptural references and build a whole doctrine around it, we now have an entire legal doctrine based upon this understanding of separation of church and state that is absolutely nowhere in our founding documents. It's absolutely taken out of context, and it absolutely contravenes and is in direct opposition to divine law and what is in our founding documents. So then the next case was Lemon v. Kurtzman in 1971, which redefined freedom of religion. And this is the test now that any appeal that goes under the Establishment Clause of religion, this is the test that the courts will look at. It's what we call a three-prong test, that any law must have a secular purpose. If it is a government action, it must have a secular purpose. It cannot be just religious. It must not have the primary effect of advancing or inhibiting religion. It has to be what's called religiously neutral. And third, it must not have excessive entanglement with religion. And if the government action fails on any one of these three prongs, then that government action is now deemed unconstitutional. And this case is one that I've actually argued before and have argued and actually wrote a paper, if anyone's interested in that, on how we need to change this test. So then let's go to Roe v. Wade, 1973. Judicial activism redefined life and ignored moral law concerning abortions. And I liked this particular clip of the two rams, pro-life versus pro-choice, because this is exactly what we're up against today, is that we're saying that we're butting heads on equal footing. That's simply not true. We have the footing in divine law. We are just refusing to utilize it anymore. And we are consenting to approaching the table under a social contract theory and saying pro-life, pro-choice, I don't know, what do we think? And that's how judicial activism was able to redefine life and ignore moral law concerning abortions and say, you know what, our society has evolved enough that we're going to have a fluid interpretation of the Constitution, completely dismissing our roots in divine law. Andy mentioned earlier Lawrence v. Texas, 2003. This was the Texas law criminalizing sodomy. That was overturned. The officer is coming into the two gentlemen's bedroom and says, "What are you doing here?" And they say, "What are you doing here?" Meaning a government action is coming in to the privacy and sanctity of the home, and judicial activism ignored the immorality of homosexuality and said, we don't have any right to legislate that, and so as a government action, we can't do that. And they used judicial activism to ignore the immorality of homosexuality. Then Van Orden v. Perry, a lot of you have probably heard of this case in 2005, which seemed to be a win for the Christian community. The Ten Commandments monument was erected on the grounds of the Texas state capitol and didn't violate the Establishment Clause. And it was held to say that it didn't violate the Establishment Clause. So we're all going, yay, we finally win. But then look at the rationale of why the court decided that. When considered in context, those Ten Commandment monuments, it conveyed a historic and social meaning rather than an intrusive religious endorsement. That's not a win for us. That is saying, yay, we won based on the social contract theory, and we are now relegating the Ten Commandments, the divine law of God, to a historic and social meaning and trivializing it, rather than saying, absolutely, it is an intrusive religious endorsement. We are endorsing the one true God, and that is the only thing that the Ten Commandments stand for. Absolutely. And so even just yesterday, there's a case that came out on redefining marriage. And if any of you are on social media or have kids who are on social media, I'm sure that you've seen this particular icon. This has become sort of the universal statement of saying equality among homosexual marriage as well as one man and one woman. This is advocating for homosexual marriage. Just yesterday, as my family and I were on the plane on the way here, and February 14th of 2014, a Virginia judge called the law upholding traditional marriage a violation of the 14th Amendment's Equal Protection Clause. This was a federal judge just yesterday. And a quote from her opinion, Judge Wright Allen said, "Our Constitution declares all men are created equal. Surely this means all of us." She went back and cut off that top of that pyramid and said that all men are created equal was declared in the Constitution. We know that's not even true, but that was her rationale. And saying, so surely this means all of us, and surely it's a fluid definition now, and we can premise our overturning of the ban on same-sex marriage just in our Constitution rather than looking back to what that really means. And then, what did we do as the Christians and fighting back? I'm not sure if the Speaker of the House, he is a Republican, I don't know if he's a Christian, but this was the other side's response. He said, Virginia's marriage amendment was duly adopted by the legislature and ratified by an overwhelming majority. So he's saying majority rules, and saying because their marriage amendment was adopted and ratified by an overwhelming majority, that should be the reason that this judge doesn't overturn it. Nothing about how it truly is unconstitutional. He goes on to say, many Virginians remain deeply committed to the traditional values that have made our Commonwealth strong. Those Virginians deserve to have their voices heard and their votes vigorously defended in court. This is our response. This is an unacceptable response. This is approaching the table saying, we agree and consent to social contract theory. We agree and consent that our basis is in man's agreement, that it's fluid and fixed, and that the power is by force of man's agreement. And as long as we have the moral majority, and as long as we have enough Christians who will voice it, that should be the reason. But that is all, ladies and gentlemen, based in the very wrong premise. It doesn't matter if I am one person up here proclaiming the truth, or if we are tens of millions of Americans proclaiming the truth. The truth does not change. That is what we have to go to the table with. Absolutely. So we need to change the basis of our appeal. We need to approach the table by saying our rights are unalienable and come from God and his divine law, not social contract theory. Our rights pre-existed the Constitution. They're not given by government. And that constitutional law and that body of law cannot be separated from moral law. You cannot separate it. Majority is not the issue. We have to stop trying to overtake the courts just by force and under the social contract theory. We have to change the basis of our appeal. We have to approach the table and say, government and constitutional law are only legitimate when in accordance with divine law and in accordance with God's authority. And therefore, ladies and gentlemen, let's become, again, true patriots. And true patriotism, I would submit to you, is advocating for divine law and our legal and lawful founding documents. Yes. And so finally, I want to leave you with this verse from Romans 13:1. Let every soul be subject to the governing authorities, for there is no authority except from God. And the authorities that do exist are appointed by God. Let's remember that today. Thank you so much for sharing this time with me.
This has been the U.S. Constitution and the Bible, presented by Jenna Ellis. To receive a free catalog of over 300 awesome Bible studies available for immediate download and viewing, or to have them mailed to you, all defending the accuracy of the Bible, information on upcoming Bible conferences in your area, or details of our missionary outreach and trips to the Holy Land, visit us on the web at compass.org or call us 800-977-2177.